Oklahoma voters will be deciding next month if language in the state constitution prohibiting taxpayer funds from being used to support religious institutions should be removed. Supporters of State Question 790 say it's needed to promote religious liberty, while opponents of the initiative argue passage will lead to costly legal battles the state can ill afford.
State Question 790 grew out of a ruling by the Oklahoma Supreme Court involving a statue of the Ten Commandments, which had been erected on the Capitol's north side in 2012. The Oklahoma chapter of the American Civil Liberties Union filed a lawsuit on behalf of ordained Baptist minister Bruce Prescott, who said the monument's presence on Capitol grounds amounted to endorsement of a state religion. The High Court agreed, citing Article 2, Section 5 of the Oklahoma Constitution, which states in part, no public money or property shall ever be appropriated, applied, donated, or used, directly or indirectly, for the use, benefit, or support of any sect, church, denomination, or system of religion. State Representative John Paul Jordan, the author of the resolution that put State Question 790 on the ballot, believes the court's ruling could have far-reaching implications.
This provision in our state constitution was like a tiger in a cage. The Prescott case essentially unlocked that cage, and we are just waiting for it to pounce. So voting yes on State Question 790 is locking that cage and getting rid of the tiger.
Jordan maintains that unless the language is removed, institutions such as hospitals with religious affiliations which accept Medicaid funds for the treatment of patients will be at risk.
I wouldn't want to be driving around the city in an emergency trying to figure out if this hospital has a religious affiliation and therefore it's not going to be able to take me in and treat me because my insurance isn't going to pay them.
Jordan says it could also prohibit Christmas light displays in public parks, such as the Festival of Light in Chickasha.
And that's property that could be perceived to be used for the benefit of a system of religion, and so therefore that's unconstitutional.
Oklahoma ACLU Executive Director Ryan Kiesel argues those concerns are unfounded.
With all due respect, I'd ask them to just read the court's opinion, and in particular the court's opinion in the denial of the rehearing, that the court said we're not even going to hear this again. We've settled this matter. They called one of the opinions called those arguments alarmist.
Retired public school teacher Jim Huff is a member of the Oklahoma chapter of Americans United for Separation of Church and State. Huff believes Oklahomans shouldn't be too quick to rewrite the Constitution, arguing the language in question was part of the core values of Oklahoma's founders.
They wanted assurance that in Oklahoma, no state dollars and no state property would ever be used for religious advancement. And so they put that language in with much more clearer distinction of what was not to be done than even the First Amendment of the United States Constitution.
Huff and others are concerned that removing the language could mean using tax dollars for religious purposes, including school vouchers.
Money to private religious schools, it's a possibility. Money to religious charter schools, it's a possibility. Money to tax dollars to religious ministries called social services, it's a possibility.
While the state Supreme Court has already ruled in favor of vouchers for students with disabilities, Jordan insists opening the door to a voucher system was the furthest thing from his mind when he proposed the legislation.
Don't be fooled by those who want to say, well, this is all about vouchers, because that's not what it's about. What this is about is making sure that this provision isn't going to be used against our counties, our cities, our municipalities, or the state itself any longer by special interest groups.
Other concerns have been raised that removing the language from the state constitution will result in more challenges in federal court, but Jordan dismisses those concerns, saying Oklahoma will still adhere to the Establishment Clause of the U.S. Constitution, which prohibits the establishment of religion.
We're not opening the doors for that, for widespread, government to be picking, one winner over another, one religion over another. That's not what we're doing here.
Still, Jim Huff is concerned passage of State Question 790 will create what he calls a giant hole in the state constitution.
This issue is dangerous because not only will it leave a hole, but without the restrictions, the legislature can do whatever the majority attempts to do.
And the ACLU's Kiesel is concerned passage will embolden lawmakers to return the Ten Commandments monument to the state capitol.
And if that happens, what I can tell you is that the ACLU and our plaintiffs will challenge the Ten Commandments monument again, but this time under the federal Constitution. And we will win again, but at this time at much greater expense to the state.